The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Thank you for joining me today for a discussion on the topic of MLMIC cash distributions. Before we begin, let me briefly introduce myself. My name is Robert Plosky. I'm excited to have recently joined Kirshenbaum & Kirshenbaum PC's litigation department. Prior to joining the firm, I spent over a decade doing complex, multi-party litigation which recovered hundreds of millions of dollars for clients. As many of you already know, Kirshenbaum & Kirshenbaum is a full-service law firm specializing in alarm law, healthcare law, and employment law, just to name a few areas. Many of our healthcare clients are providers, but we also represent employees. Recently, we've been receiving a lot of questions from our clients about the MLMIC buyout and conversion, which was the impetus for this webinar. Okay, let's get started. MLMIC, or Medical Liability Mutual Insurance Company, is one of the largest providers of medical malpractice insurance in New York. On July 15, 2016, MLMIC announced that it was being acquired by National Indemnity Company. In the acquisition, MLMIC will be converted from a mutual insurance company owned by its policyholders to a stock insurance company owned by National Indemnity Company. MLMIC will receive $2.502 billion in the buyout. MLMIC will be distributing this money to its policyholders or to their designees, which we will be discussing shortly. Policies receiving a distribution must have been in effect between July 15, 2013 through July 14, 2016, which we'll call the record period. The portion of the money distributed for each policy in effect during the record period is approximately equal to 1.9 times the sum of the premiums paid on each policy during that time. As an example, if the total premiums paid on a given policy were $500,000, the distribution will be approximately $950,000. Because of the amount of money involved, it is extremely important that everyone understands who will be getting the money and how to ensure that you protect your rights to the distributions. Over the past few months, MLMIC has told us they've been inundated with questions and concerns from practitioners and employees. This is especially true over the past few weeks. Unfortunately, some of this appears due to issues that MLMIC either didn't consider or didn't think to address when it distributed its policyholder information statement on June 22, 2018. Hopefully, this presentation clears some things up. According to the policyholder information statement, MLMIC's default position is to pay the cash consideration directly to each named eligible policyholder. An eligible policyholder is the person identified on the declarations page of a particular policy. However, if the eligible policyholder designates a named policy administrator or EPLIP employer, also would be named on the declarations page of a particular policy, to receive the distribution, it will go to those designees instead. Here's MLMIC's official statement on the issue from its policyholder information statement. I won't read the whole thing, but it's pretty much exactly what I just said. To facilitate this type of designation, MLMIC has mailed out consent forms to policy administrators, EPLIP employers, and eligible policyholders. According to MLMIC, these consent forms must be returned to MLMIC before the public hearing of the New York State Superintendent of Financial Services, which is taking place this Thursday, August 23rd, 2018. If you look on this slide, there's a sample consent form, or this is just a particular consent form for somebody that's been blacked out. This is what MLMIC was sending. If you aren't familiar with these forms, then you're likely not a named policy administrator or EPLIP employer, and you have other issues that we will be discussing shortly. Again, if MLMIC doesn't get the completed consent form by the date August 23rd, 2018, they say they won't distribute the funds pursuant to the forms. In other words, the default position will control, and the named eligible policyholder will receive the funds. So you could be a policy administrator or an EPLIP employer, and you haven't yet discussed this issue with your employee or former employee. or you haven't heard back from them otherwise, and you want to get this form signed, well, it's probably too late for that, because by the time you get the form signed and get it back to MLMIC, Thursday will already have come and gone. So if that's the case and you believe you're entitled to the funds, you should file an objection just to be safe. We'll be discussing that shortly. Aside from designating policy administrators or EPLIP employers to receive the distributions, MLMIC has stated that eligible policyholders have the right, outside of the plan of conversion, to assign their right to receive their allocable share of the cash consideration to others. In other words, they can assign it to people who are not, or to employers, I should say, who are not the named policy administrator or EPLIP employer. This statement was posted in an update on MLMIC's website on August 7, 2018, along with a form assignment agreement. So this shows that MLMIC is still sort of trying to explain everything to everybody. The website address is on the slide. And I'm going to show you now an image of the assignment form that MLMIC put out. It's a sample. Okay, now let's discuss a few common scenarios we've been hearing about from our clients. In scenario number 1, which is the most common, I would say, a named policy administrator or EPLIP employer has paid or reimbursed 100% of the premiums for an employee during the record period. The employee wants to retain all of that money and refuses to consent to designate the employer or doesn't timely respond to such inquiry. What can the employer do? Okay, so this situation covers what we discussed earlier, where you're a policy administrator and you haven't gotten around to getting your consent form signed or discussed it with your employee. So that situation is also included here. MLMIC says that the employer can send MLMIC a letter or preferably an email before August 23rd, Thursday, which states that the employer believes it has a legal right to receive the cash consideration and is objecting to the distribution to the employee and has provided a copy of such correspondence to the employee. This is in the policyholder information statement. At that point, MLMIC will hold the allocation of cash consideration in escrow, which essentially freezes the distribution and preserves the status quo until MLMIC receives further instructions. MLMIC has said that the money will be held in escrow until either it receives joint written instructions from both sides as to how the allocation is to be distributed. In other words, the two sides are going to negotiate, speak to each other, and get back to MLMIC and say, we worked it out, and here's what we'd like you to do. Or a non-appealable order of an arbitration panel or court with proper jurisdiction ordering the payment of the allegation to one of the sides. So in that scenario, the two sides are going to have a disagreement and they're going to take it to a neutral party, such as an arbitrator or court, to work it out for them. The outcome of litigation or arbitration can't be predicted with certainty, but it may depend on the terms of the employment agreement at issue. We've seen several of these agreements, and they're generally very similar. The outcome may also, however, depend on actions you have taken prior to litigating or arbitrating, which is why it's so important to have competent counsel by your side well prior to initiating formal proceedings. At Kirschenbaum & Kirschenbaum, we're here to help make sure that your rights are protected and you are not prejudiced by your own actions or those of others. Okay, here's another common scenario that we've been seeing. Basically, in this scenario, it's just like the first one, except the employer was not a named policy or designated policy administrator or EPLIP employer. And there's a disagreement with the employee about who can get the funds. So MLMIC hasn't specifically addressed this scenario in writing, but they've told us over the phone that they will likely not honor objections by the unnamed employers, which is what I defined in the scenario, to hold the money in escrow. So if you're a named policy administrator or EPLIP employer, or you're listed on the policy, you have this right to object. But if you're not, and you still paid 100% of the premiums, or you reimbursed your employee or former employee for the same premiums, MLMIC has said to us over the phone, they're not likely to allow you to object. Or if you do, they won't honor it. But again, to show how things have been changing, MLMIC also said more recently to us on the phone that making those types of objections couldn't hurt. So we recommend making the objections as if you are a named policy administrator or EPLIP employer and hope that MLMIC honors it anyway. It's just an extra step you can take that may protect your interests. Again, these objections would have to get in to MLMIC by August 23rd. If MLMIC doesn't honor the objections, you have a few legal options you can take to try to have a court put the money on hold as if it were placed in escrow. And there are other options as well. You should contact us if you are in this situation and we can advise you of your specific options. All right, so this is going to wrap it up, and I kept it short. Time is running out, so you need to contact us if you have any questions as soon as possible, and be sure to get your objections into MLMIC before Thursday's deadline. If you'd like assistance in that regard or would like to speak with us about your specific situation, which we're doing for many of our clients, please contact me at RPlosky at KirschenbaumESQ.com. You can also contact my assistant, Taryn, and she will help schedule a 1 half hour consultation. And of course, you can contact Jennifer Kirschenbaum at Jennifer@KirschenbaumESQ.com, who all of you certainly know. And for any of your legal needs, you can go to our website, www.KirschenbaumESQ.com. You can sign up for our healthcare newsletter, which I'm sure many of you already signed up for. And I want to thank everyone for listening today and for joining me for this presentation. Have a great day.